Lordship, I have a two petition for admission hearing. It may come up any date in the first week of the March. The matter is about the distribution of PDS articles.
First week of
March, April.
admission not possible last week of March. Ninth and 10th will be holidays.
Thereafter any date, Lordship.
Day after holidays,
And
maybe after Bihu. 20 or 22nd, 22nd.
22nd, Lordship.
Yes.
It pleases Lordship. Lordship, I have a prayer for listing 3603 petition number 3606 of 25 for withdrawal, Lordship. For tomorrow, can it be given, Lordship? Obliged, Lordship.
I'm praying for listing of a motion matter tomorrow.
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 But is it,
There's some urgency, Lordship. My development work certificate, Lordship. 3 years after completion, Lordship, they have cancelled my development certificate. And that is hampering my participation in other bids, Your Lordship.
can it be on Friday?
Tomorrow, Your Lordship. Tomorrow.
Friday.
There is some urgency on our part, Your Lordship. There's outstation council also. That is why tomorrow, Lordship.
Okay.
Daily list, order no steps, item number 1.
Well, inadvertently we skipped, my lord. We are taking it today, my lord.
Hmm. What is this IA?
My lord, we skipped to my lord, implement the principal secretary of Karbi Anglong Autonomous Council. So, as per
Okay.
Harwell direction, we have filed the IA.
Okay, this can be allowed.
Okay.
The Third, Mr. Any health? Health.
Earlier, Mr. D. Upomentra appeared.
Third, Mr. Ankit Political and talk about a petition. First of the Land Standing Council. The Land Standing Council. Welfare Department Assam. Is found absent to government. Miss Asking, right? Standing Council. Karbi Anglong Autonomous. You are Standing Council? Standing Council, Karbi Anglong Autonomous Council for the opposite party number 3 and 5 is present. Post of the instant interlocutory application is preferred by the applicant. Speaking of
Karbi Anglong Autonomous Council represented by Principal Secretary.
bring authority. Bengal Autonomous Council, DFU represented by the Principal Secretary as party response number 8.
7, my lord, it will be.
Okay. Sorry, Karbi Anglong Autonomous Council represented by the Principal Secretary, DFU, Karbi Anglong, Assam, PIN 782460 as party response number 7 in the accompanying writ petition. First of the accompanying writ petition is preferred by the applicant as the writ petitioner seeking direction to the respondent authorities therein to pay disbursement amount of rupees 1 crore 96,72,000, which amount, the petitioner, the petitioner claims which amount the petitioner claims to be due as against supply orders executed is averred, right, is averred that for adjudication of the issue raised, the presence of the proposed party respondent number 7 is necessary. Post of the learned counsel for the opposite parties have submitted their post of in view of the above. This court is having regard to the issues raised in the issues involved in the accompanying petition. This court is of the considered view that the presence of the proposed party respondent is necessary for adjudication. So according, the instant interlocutory application is allowed. The counsel for the petitioner shall file an amended cost title within, in terms of censor, within 3 working days from today, before the registry. And upon submission of such amended cost title, the registry shall carry out the necessary correction in the cost title as well as in the CIS post of para. In the you were appearing standing counsel, Health and Family Welfare Department for the opposite party number 1, 1, 2, and 4.
1, 2, and 4, Lordship, I am appearing.
In the petition. Mr. N.K. Kolita, learned counsel for the petition. You point, no? Standing counsel, Health and Family Welfare Department for the respondent number 1, 2, and 4 as Camprai Learned Standing Counsel. Counsel for the respondent number 3 and 5.
And 7 will also be.
And 7. No, yeah, this they have to be corrected first of. Peruse the office note dated 23/2026, where it is stated that, wherein it is reported that the petition has not taken steps for service of notice upon the respondent number 6 in terms of the order dated 13/2/2026, post of para. Mr. Kolita, learned counsel for the petition, has submitted that he would take the required steps within a week from today. And he may be permitted to take steps upon the respondent number 6 in reference to the order dated 13/2/2026. Post of para. By an order dated by an order passed today in ISC number 560/2026, party respondent number 7 has been newly impleted. Post of the petition has been filed down. Amended cost title within 3 days from today, 3 working days from today. Post of in view of the same. The petition is allowed 3 working days time. The petitioner is allowed to take steps upon the respondent number 6 by speed post within 3 working days from today. Release the case. Ms. Camprai has submitted that she would accept notice on behalf of the newly impleted parties from number 7. Post of the learned counsel for the petitioner shall furnish an extra copy of the petition Allowed annexer to Ms. Kemprai. We read you working this from today for service of notice under as per number newly implemented as per number 7. So please the case on after Bihu.
11th May, 11/5. For admission, item number 2.
Lordship, here in this matter, already Lordship proposal for financial sanction has been placed before the government, Lordship. So I need 2 weeks time to place the
Okay.
instruction. He can have a copy.
Mr. J. Singh, learned counsel for the petition is present. Post of Mr. E. Upamoinu,
Or
learned standing counsel, Health and Family Welfare Department, appearing for the as per number 1, 3, and 4.
and 5, Lordship.
1, 3, 4, and 5. Has submitted that. Yes,
No,
what?
Lordship, I am for 4, 1,
Huh?
3, and 4.
1, 3, and 4. Racing and Miss Udas, huh? Udas ran it. Additional senior government advocate for the husband of 5 are present. Finance and Mr. Solia, standing counsel, Finance Department for the husband number 2 are present. Mr. D. Upoinal, standing counsel, Health and Family Welfare Department, appearing for the husband number 1, 3, and 4, has submitted that yes.
That proposal for financial sanction has been placed before the Joint Secretary by the Directorate of Health Services, FW.
A proposal for financial sanction. For an amount for a sum of rupees 9,79,545 payable to the petitioner has been forwarded by the respondent number 4
Sure.
to the respondent number 1 on 3/2026. Postal. Mr. Upamoinu has sought for listing of the case after 2 weeks in order to place up-to-date instruction before the court. The court release the case on Friday. To enable Mr. Upamoinu place up-to-date instructions in the matter.
4th May, 4/5.
Highly obliged, Lordship.
3. Item number 3. Your Lordship.
What they have filed in their affidavit may I just show. Jim.
Okay, let him say. Okay, brother.
Basically, my entire ambit of argument is very centered to three issues. Whether the respondent number 1 and 2 could lawfully introduce post-evaluation relaxation such as provisional evaluation or a 96-hour rectification window when the tender document contained no such stipulations. Absolutely silent manner to that extent that whether the correction could be made after publication of result. And number 2, my lord, whether the selective re-evaluation of respondent number 4's bid after publication of technical results vitiates the sanctity of the bidding process. Now let me get your lordship into the tender document, my lord. But it starts from page 12, annexure 1. And the operative part is, my lord, 18. Page 18. Has your lordship got it? It starts from 4, my lord. First paragraph. None of the staff of NHIDCL, their relatives, or any of the contractor, vendor, agencies assigned work contract in NHIDCL will be considered for bidding for hiring of vehicles. A certificate in this regard should be furnished by the bidder along with technical bid. My lord, it's very specific, my lord, because they are portraying one particular document that is undertaking. Undertaking, my lord, is a different thing. Undertaking is to act or not to act. But certificate is an assertion, my lord, which was not in their tender document. A certificate in this regard should be furnished by the bidder along with technical bid. Well, it is not there. Well, next page. 37, my lord. No, well, 23, page 23 of the tender document. For a moment, my lord, page 22, last paragraph, my lord. Just to have something, my lord. 3.1 clause. The financial bid should include the cost associated with the assignment. The financial bid should be prepared strictly in accordance with the format specified. In financial bid, the financial bid should clearly indicate the amount without any assumptions or conditions attached to such amount. Conditional offer or proposal not furnished in the said format shall be considered non-responsive and is liable to be rejected. Next, my lord, 3.5. Page 23, my lord. Number 4. Submission of proposals. The bidder shall submit the technical bid and financial bid online through government e-market, that is GEM portal. Bid document must be submitted both soft copy in portal and hard copy in RO Gauhati address, my lord. Now next 5, number 5, proposal evaluation, very important, my lord. 5.1, evaluation of technical bid. The proposals would be evaluated by an evaluation committee. A 2-stage procedure will be adopted in evaluating the proposal. In the first stage, the technical bid will be opened by the evaluation committee, RO Gauhati, NHIDCL, and will be examined as to whether the documents are properly signed by the bidder, the proposal has been received on or before the deadline submissions, the information to be furnished by the bidder regarding details of the vehicles being offered should be complete in all respects and should be in conformity with the manner in which the information has been sought in the technical bid. Very precisely written, my lord. Thereafter, this demand draft and all, in case, this is important, my lord, in case answers to any of the above items is no, the bid shall be declared non-responsive and shall not be evaluated further. Thereafter, my lord, after examining the proposal of the above grounds, the committee shall shortlist the bidders on the basis of the information provided in their technical bid corresponding to the requirements set forth. The decision of the committee shall be final and binding. Thereafter, my lord, the financial bid of only those bidders shall be opened and evaluated further, which have been declared pass in technical evaluation by the committee. All the conditions are set forth under clause 2.1. My lord, I'll come little later to 2.1, my lord. What are the relevant documents they have to attach while filing their tender document, my lord. Now, all the conditions as set forth under clause 2.1 shall be met for technical eligibility of the firm. My lord, I'll come little later, 2.1, my lord, for a moment. Then, lordship, page 26. 26, item number 2, my lord. Para 2. Technical bid is meant only for all technical details as mentioned in LOA. Please note that monthly rent, etc., should not be indicated in technical bid. In case any financial details is found, the bid shall be declared technically non-responsive. Well, on that, let us come to 10, 10 number. Page 26. The evaluation committee of NHIDCL RO Gauhati reserves right to seek confirmation. Well, very, very important, my lord, for which they are also putting this, my lord. The evaluation committee of NHIDCL RO Gauhati reserves right to seek confirmation, clarifications of any document of the bidder issuing authority of such document during the process of evaluation. My lord, what is the process of evaluation is very important, my lord. Not after publication of result. Seeking certain document for correction of their bid document after publication of result is absolutely against the principle of law set by many judicial pronouncement, my lord. Hereafter, my lord, page. Now, let us come to page 37. Which precisely, my lord, before that, my lord, I need to point it out, my lord. They are saying that after rechecking, my lord, after rechecking, they have found that this particular document which was sought after publication of result for correction, it was there. They have said, my lord, respondent number 1 and 2 has categorically stated in their affidavit that it was there. Now, what is that document, my lord? Precisely the format for notarized undertaking by the bidder. Now, in 2.1, lordship, let us get into the 2.1. Page 18, my lord. No, I'm sorry, my lord. Page not 18. 2.1. Just a minute. Yes, page 21. 2.1 clause, my lord. Document in support of technical bid. Now, 2.2, the following documents must be uploaded along with technical bid. A copy of the registration certificate, pro forma invoice, etc. B, PAN number of the company, farm, agency. C, GST registration. D, bank account details. E, Aadhaar proof, voter ID, etc. F, details of the vehicles offered and its registration and owner details and all, my lord. That's G. Well, it's very important. Undertaking on stamp paper for providing vehicles in case of award of work. If the award of work is given, in the pretext, my lord, this particular document has to be given prior to that, my lord. Undertaking on stamp paper for providing vehicles in case of award of work. Then earnest money, my lord, these are not pertinent, my lord. These are required document, my lord. Now let us come to the page 37 again, my lord. This is the format that they have given, my lord. Now, para 4, my lord. Just see para 4. This is one of the recitals, just one of the recitals among other recitals too, as per the tender documents requirement, my lord. I am neither staff of NHIDCL nor related to any staff of NHIDCL, staff as deputation or contractual basis, outsource agency. This is the single paragraph, my lord. But so far tender documents requirement is concerned, there is a specific assertion that one certificate has to be issued. Now, again, let us take to that particular
Page number 18.
But kindly come to page 18, my lord, again. Page 18, item 4, my lord, the first paragraph. None of the staff of NHIDCL, their relatives, or any of the contractor, vendor agencies assigned work contract in NHIDCL will be considered for bidding for hiring of vehicles. A certificate, my lord, this is very specific recital. A certificate in this regard should be furnished by the bidder along with technical bid. Now, what is that certificate? Well, quite evidently, the certificate was not there. There was one undertaking where only one paragraph, one line, one sentence is there. Apart from other conditions in that undertaking, my lord. So undertaking, my lord, is always given for to act or not to act. This is called undertaking, my lord. So far I understand. What is the meaning of undertaking? Is that I must work or I must not work. To that extent, I'm issuing one undertaking. Certificate, my lord, dear, is specific session. A certificate in this regard should be furnished by the bidder along with technical bid. Where is that certificate? That certificate was not there. Now,
Where is your certificate?
my lord,
Where is your certificate?
my certificate, yeah, there was no dispute about that. I submitted it, my lord.
Okay, original bid খিনি আছে ন?
Now, my lord, what is the content of certificate?
Whether this, apart from page 37,
My lord,
authorized undertaking
Hmm.
by the petitioner,
my lord,
he has also submitted a certificate.
my lord.
Is it your case?
Petitioner, no. My case is altogether different, my lord.
No. You have submitted a notarized undertaking in the prescribed format as shown in page 37,
My lord,
right?
my lord,
Apart wherein this clause 4 is there,
my lord.
right? And apart from that, you have also deposited a certificate.
Yes. Yes, sir. Yes, lordship. Since there was no question, my lord, I was qualified by the department, my lord. I was qualified. There was no question of what you call that lacking of any documents at the time of submission of my bid document, my lord. But I found, my lord, for respondent number 4 and another, my lord, the bidder, my lord, they didn't file it. So that's why possibly, my lord, I'm terming it possibly.
No, not possibly. Here, no possibility.
Well,
Perhaps all these things are not here.
my lord, they have
Respond number petitioner আছে নেকি? No, ভিতৰত? No, ভিতৰত? নাই। নাই। Yes, petitioner's bid is part of your affidavit, no? So was which certificate?
my lord, I'm just showing it, my lord, which they have filed, my lord, with number 4. Page, my
No,
lord.
their certificate I know. Their notarized undertaking, that is the issue. But where is your certificate?
I didn't annex it.
Right, do you have
It
the
was-
certificate?
My lord, it was not at all issue, my lord, in my case. My single point is that
Who will issue such certificate?
certificate will be
Who will issue?
self-certifying, my lord. I'll have to issue a certificate on my behalf that I certify that nobody of my family is engaged or involved or connected in
That is
any manner.
already there in clause 37.
Kindly see, my
What
lord.
is undertaking is, this is, I am neither staff of NHI DCL nor related to any staff of NHI DCL, staff such as deputation, not on contractual basis or outsourced agency,
Oh,
right?
yes, lord.
Then what more is required?
Now, clause 4 says that, my lord, a certificate in this regard should be furnished by the bidder along with technical bid. My lord, why I'm putting this particular issue, my lord? Because the NHIDCL says that sought some document with a view to correct it. So now for respondent number 4, my lord, this particular document, my lord,
No,
the
seeking document.
So-
Seeking document is another thing. Mr. Proceeding, seeking document is beyond the purview,
my lord,
right? Yes, for clarification, it can be. Seeking new document is not part of the bidding process.
true, my lord.
But seeking
I'm correcting it.
clarification within the realm of jurisdiction of the any tendering authority, that is, that much free play in the joints is available to the tendering authority,
Absolutely.
right?
Absolutely.
Seeking clarification, yes, this document is, we found that this document is something not fully understandable to us. Tell us, right? They can seek clarification.
Definitely.
And secondly, a document, suppose scrutiny is made. If somebody says Yes, there was oversight on your part. Right? Please redo or re-scrutinize my technical bit. That undertaking is available. Right?
Right.
That is also within the jurisdiction of the
Fine, Lordship.
and
but
the
not
authority.
after
Otherwise,
completion of result.
so what, so that no fault occurs.
My lord.
Right?
True.
Even if it is 22/10/2025,
Right.
it is final. Even then, if something has occurred, then it can re-scrutinize the bid again to find out whether any fault occurred earlier.
My lord, the scope is limited here.
Scope
Once,
is limited.
my lord, once the result is published, my lord, there is a latest
Making-
judgment.
Mole, a mountain out of molehill is also forbidden,
My lord,
right?
even my lord, Supreme Court in the latest judgment says that not even typographical error. There is a landmark judgment, my lord, with authored by Justice Honorable Ujjwal Bhuya, my lord. Fantastic judgment, my lord, taking lot of judgment as a reference there, saying that after publication of result, correction, even the typographical correction cannot be done. I'll place it, my lord, before your lordship. So
Tell me, what is your case?
my point solely on that. But since this particular issue has come up, my lord, what I thought, my lord, the NHIDCL might have thought of that this certificate is not there, but asking or for opening up the rectification window after publication of result was against the principle of law. That's my case, my lord. That is the thing, my lord. Read document of me. Another important issue, my lord. Page 105 of the technical bit. Kindly for a moment, my lord. But they are saying that, my lord, there is a window.
Just a minute.
Right.
So in your writ petition,
My
come to page annexer 2, though it is not, yes, annexer 2.
Two, my lord.
Annexer 2, page 43.
Page 42. Yes, lordship.
They, this is the one which was uploaded on 22nd of December,
My lord.
right?
Screenshot. I took it.
And in the extreme right column,
My lord.
there is a view icon.
My lord.
And that is the case that view icon, madam, please sit.
Yes, yes.
This is not the practice here.
My lord.
We don't look at two councils at the same time. View icon.
My lord.
Now, come to their affidavit, respond number 1,
My lord.
right? They say by clicking the view
Right, my
icon,
lord.
come to page, internal page. There is no internal page. Page 62, running page 62.
My lord.
They claim it to be provisional, but if you click the view icon, these are the regions shown,
My lord.
right?
My lord.
And they say that this permits the bidders
My lord.
to make a representation. Another thing is there that respondent number 4 had uploaded another document. That is another issue, right? But the NHIDCL says that this particular undertaking, page 37 undertaking, notarized one, dated 2/9/2025, was part of the record.
Process.
That is what they say.
Fine.
According to you, that this 22nd should be final.
Fine.
Because your repetition is not, there is no statement as regards uploading of the results on 30/10/2025. Your repetition is speaking about only uploading of financial bid evaluation. That aspect is not available in your repetition. 30/10, there was another uploading wherein 4 have been declared responsive, including the respondent number 4. Right? That part was not there. You said that surprisingly, financial bids were found open.
My lord.
Is
Now-
it not?
No, correct, my lord. Now, what actually had happened, my lord? They have taken, my lord, quite right. Your lordship rightly said that in the website, my lord, in the GEM portal, my lord, there is a column view. My lord, I'll come to that particular issue, my lord. How GEM portal functions. Now, GEM portal is a common platform for all the organizations who are utilizing it. Now, it has got multiple features. I've got a specific recital in my affidavit in opposition. I mean, in reply to the affidavit, my lord. It has got multiple features. Now, there has to be a human interface. Which particular facilities or advantages I have to avail or I will avail?
Please tell me, because it is not a decision, it is a decision-making process.
My lord.
Right? We examine only the decision-making process.
My
So, where the fault lies?
Fault solely lies on the particular issue that after publication of result, which is absolutely against the principle of law, they could have sought clarifications, not after publications. Now they are taking advantage of GEM portal's advantage or the features that must have been written in the tender document. In the entire tender document, it is there. If the buyer wants to have some clarification, they can seek during the process of evaluation. But the process of evaluation ends the moment result is published. Where there is a scope.
Okay.
Now, my lord, can you see page 105? Interestingly, my lord, they've said that 96 hours window, what actually is recited there. What you will find. My lord, see, there is 1, 2, 3, 4, 5, 6, 7 parameter column. Time allowed for technical clarifications during technical evaluation is 4 days.
Para?
My lord, para 7. Column is there. There is a
1 minute. Pages are repaginated.
oh,
105. Okay. 105.
Five.
Bid details.
5.
Okay.
The details 1, 2, 3,
Hmm.
4, 5. That's 7 row.
What is the heading?
Well, the time allowed for technical clarifications during technical evaluation. That they're saying that there is a 96 hours window, even after publication of result, they can rectify. I mean, the bidders can rectify their defects, my lord. Absolutely wrong. Now, time allowed for technical clarifications during technical evaluation. not after publication of result. It is there very precisely and specifically written, my lord. Now, Lordship, come to the page 115.
So from here, it seems
My lord,
that technical evaluation process,
my lord.
one is 22nd, 10, 2025.
My lord.
It is technical bid evaluation, opening.
Opening. Once opened and the result declared,
No, result is not declared.
qualified.
No, if it is time allowed for technical clarification during technical evaluation,
Yes.
meaning thereby,
Yes.
maybe it is a different issue, but technical bid opening and opening particulars are made available to all.
Yes.
Otherwise, why 4 days?
Without opening, they cannot even know what documents are not
Because
there.
all the bidders
Ah,
should also know
my lord.
the details
Yes.
of the other bidders.
Yes.
Right?
Yes.
It is not, as said in AFCON, it is not that only the employer or tendering authority can find fault. It is the other
Yes, sir.
participant bidders
That's why.
who can find more fault
Yes.
in their rival
Yes.
participants'
Yes.
bid.
Yes. Yes.
So it is open for all. Click the view icon, see the grounds of rejection and see the ground
Very nice.
of acceptance. Then he can see the bid also.
Right.
Right. And thereafter he can make a comment, no, look here. This man is
No,
declared.
my lord, little bit subject to correction, my lord. To that extent, GEM doesn't allow. I have to log in into the portal, my lord, of my own credentials, and I can see of my own only. The defects can be seen by myself only to the extent of my defects, my lord, not others. That is there. Now, here, my lord, definitely it's quite good process, my lord, that during the process of evaluation, the party can sit or may clarify. Again, my lord, 115. Page 115. Adil Rashid Bab. Last page, my lord.
Yes.
1, 2, 3, 4, 5. 5, matlab, my lord, 5, paragraph 5. Further, if any seller, as the lordship said, further, if any seller has any objection, grievance against these additional clauses, my lord, there are certain clauses are there, or otherwise, or any aspect of this bid, they can raise their representation against the same by using the representation window provided in the bid details filled in the seller dashboard after logging in as a seller within 4 days of the bid publication, my lord. Bid publication. Now, what is the meaning of bid publication? 4 days of the bid publication on GEM. Buyer is duty bound to reply to such representations and would not be allowed to.
This is some kind of pre-bid
Lordship.
clarification.
Yes.
This,
Now
this
they are saying
115 is some kind of pre-bid clarification.
before submissions. Before submission. And that is also 4 days, my lord. That window, 96 hours. That is
That
the
is
thing.
not applicable here.
Now, in their affidavit, my lord, respond number 1 and 2. And more importantly, my lord, the respond number 4 in their affidavit nowhere mentioned that they had already submitted the certificate. There is no recital.
That is why for that precise confusion, we had directed
Mani.
the respondent number 3 to file the affidavit and to bring in the technical bit of the respondent number 4 on record.
Mani.
Right? That is the deliberation we had because of the stand taken by the respondent number 4 in their affidavit and because of the stand taken by the NHIDCL
Very correct.
in the affidavit, we found some variance, and that is the precise reason we had directed the respondent number 3 to file the affidavit,
Very
bring
correct.
on record
Very
the
correct.
technical bit of the respondent number 4,
My lord.
so that everyone can see whether the undertaking is part of the technical bid or not. And thereafter, we do not go into roving inquiry. We do not go into roving inquiry, this or that. If they are a neutral party, we had asked them to file it.
Right.
Right? They are only intermediaries or facilitator of the platform.
Yes, yes,
Right.
absolutely.
So we have asked them to do it. Right? And what is their stand? I have not seen. Right? But only for the purpose that because of some the stands are at variance to each other.
Yes.
Response number 4 said, in the window, I deposited one document,
My lord.
right? Undertaking, which is not an authorized one, right? And their stand is that it is part of the technical bit. And because of that precise reason, because we do not go into fact-finding inquiry, we base on our decision on affidavits, and finding that response number 3 is a facilitator and platform provider, we ask them to bring in whether it is possible for you to bring the technical bit of the response number 4 on record or not, right? And they have filed the affidavit because we do not rely on the documents produced by the response number 1 on an earlier date.
My lord.
Right? This is the reason, so that everything is clear that what comprises in the technical bid of the response number 4. Right? And so far as the deliberation was earlier, only with the undertaking. Had you argued that this certificate is another thing other than then I could have called your bid also.
My lord.
Now, this is a new argument that you are making. Though I am hearing it,
My argument is
and
absolutely.
your repetition is structured on what basis?
My lord.
It is the undertaking at page 37,
My lord.
is it not?
My entire repetition, my lord, based on the single, my lord, the point is that post-bid correction is.
Right, decision-making
thing.
process
Yes.
by by making a scrutiny of the bids, right, after 22nd
My lord.
is not permissible, that is your case,
Yes, lord.
right? And then bringing in 2 more bidders as technically responsive, thereby making it 4 technically responsive bidder is not as per the terms and conditions of the tender document. That is your case,
Absolutely.
right? If I have understood correctly.
I just make,
And
I
then
make it before your lordship. Only the reference has come. Your lordship has put some questions. I thought it is my duty.
you're sure that
My
is
duty to apprise your
because
lordship.
for
That's
the
all.
court, it is
My-
very difficult
My lord.
because of the stand taken by the NHI DCL and the response number 4.
My lord.
And for that reason, the response number 3 has been
My lord.
directed to place on record the technical bid of the response number 4.
My lord.
Sometimes it happens that counsel is not properly instructed also.
My lord.
So let us have the documents.
Very fairly. my lord.
Right.
Absolutely. Oh.
Man may lie, document would not lie.
Yes, your lordship. True,
Right.
true, true.
Man
Absolutely.
can lie at any moment,
Absolutely.
according to the situation. But document, once it is there, that will speak the truth. That is why, that is the reason
I-
precisely I have asked the response number 3 to find.
Even my lord, on the first occasion, just to.
Though
tell
I am
your
not
lordship-
very happy with the statement that why we should be brought in. I'll make a adverse comment on it. Whatever.
Should not be once.
You are one, you are enjoying, you are making a platform. If some dispute comes, definitely you have a role. What kind of statement you are making, Mr. Kothari? You try to put the blame on the court, or what? That we, look here, I am in the position of a president, don't bring in.
No, no.
Don't bring me in. What is this?
That Advice, but the format based.
Then you agree to their advice
No, Lordship.
and put it in the affidavit.
I apologize, sincerely apologize.
This is not the way to make a statement before the court. Yes.
But-
If I find next time,
Well, I'll take your lordship to the.
don't think yourself above everybody.
My lord, just I'll take your 2-3 paragraphs, my lord, of the rejoinder filed by the respondent number 1 and 2.
1 and 2 affidavit.
Affidavit, my lord, rejoinder. After filing our reply, they filed. Page 90, it starts from page 90, my lord.
Just paginations are different. Just a minute. 90.
It is, my lord, rejoinder filed against affidavit in reply filed by the petitioner. The affidavit in opposition, my lord.
Yes, please.
Here, my lord. Paragraph 7. Paragraph 7, my lord, page 93, lordship. That is regarding the statement made in paragraph 4 of the affidavit in reply filed by the petitioner. Now, so answer, my lord, it is replied that as per clause 5.1, my lord, they have admitted here, as per clause 5.1 of the bid document under heading evaluation of technical bid, is stated that the two-stage process will be adopted in evaluation process. It is clearly mentioned in RFP that the financial bid of only 2 bidders shall be opened and evaluated further, which have been declared pass in technical evaluation by the committee. And after technical evaluation of the technical bids, results of the evaluation committee is uploaded in GEM portal under 2 categories, that is qualified and disqualified, giving due reasons for being disqualified. Now, my lord, this is very important. After publication, what was the term, my lord, they have used? Disqualified and qualified, giving reasons for being disqualified. Now, there is no such recital or statement that there is a correctional window. My lord, GEM might have that features because I've gone through, my lord, extensively about the process they function, my lord. There are numerous features. Now, what features to be used by the buyer has to be a specific mention in the tender document, my lord. There was absolutely silent. Now, and it is also to be replied herein to the bid document number so and so dated 23/8/2025, where the bid details have been mentioned with general rules and regulations, has already been uploaded in the GEM portal, and there was a clear provision that, well, kindly see, there is a clear provision in the said bid document where it states that time allowed for technical clarifications during technical evaluation is 4 days. Now the stand changed after filing my reply to their affidavit in opposition. What they said, time allowed for technical clarifications during technical evaluation is 4 days, that is 96 hours. Very correct, my lord. Now there is rectification window is absolutely vishes the process file. Not paragraph 9, my lord, page 95. No, it's not against. Now, paragraph 9, last paragraph, my lord. Page. Subsequently, post evaluation of the representation. Well, let's see how the recitals comes up. Subsequently, post evaluation of the representations of the aforesaid 2 bidders, namely Messrs. Kamakya Travels and Sonu Enterprise, the technical evaluation committee declared the following 4 bidders are technically qualified. What they said, my lord, post evaluation of the representations. This is a new sort of recital they have brought in, my lord. Next, page 10, my lord. Page 96, paragraph 10, my lord. 1, 2, 3, 4, 4th line, my lord. Paragraph 10, 4th line. The financial bid was opened on 30/10/2025 on the basis of technically qualified bidders who were declared qualified post evaluation of their representations within 4 days, that is 96 hours, as per provisions of GEM. This is wrong. This cannot be. As the entire tender document, bid document, there is not even a whisper about any correctional window. Now, another important aspect they have brought in here. Look, last line of page 96. Last line, Lordship. Just one particular paragraph, my lord, line precisely. The L1 bidders, namely Messrs. Kamaikya Travel, was declared as by the GEM portal using auto selection process of GEM portal without any manual interference. This is wrong. This is absolutely wrong, my lord. Because without human interface, this entire portal cannot function.
We are basically into bringing in 2 more bidders.
My lord. My lord. Yes.
Few things which are not necessary for
Fine,
our
fine.
decision.
I
We are
understand.
not going
I
to,
understand.
right? We are
Understand.
only looking at
On that particular.
how these 2 bidders who were declared non-responsive earlier could be brought in.
My lord.
Thereafter, what is the price bid that those are then assessment? If you have made any challenge regarding that, no,
There is no issue.
I should not be declared L1 on the basis of the parameters I have figures I have placed.
No, I'm not.
So
No,
that I will not go into. Unnecessary
In the-
exercise.
My lord, in
These
the
are
latest-
unnecessary
In
exercise.
the latest judgment, my lord, I've read the judgment. I'll pass through, Lordship. There, the Supreme Court has categorically stated that one bidder, but there was one assertion in the tender document that the amount to be quoted, which to be calculated for a period of days where the engagement would be there. The period per day into the entire period, there is 1,000 some days. Now, the bidder, my lord, who was in question, he simply wrote per day amount to be given.
No,
Now,
here, this is not a sir.
Very interestingly, this particular fellow, my lord, moved to Calcutta High Court. The single judge, my lord, dismissed it. Then an intercourt appeal, division bench allowed. That particular judgment was set aside, my lord, by Supreme Court, saying that no, post-bid correction, even the typographical error, cannot be. That's my case, my lord. I'm just sharing, my lord, the bunch of judgment, my lord. You can see. The first one is, my lord, I'm referring the similar judgment, and the first judgment, my lord, there are certain judgments. 3 judges bench of Supreme Court, my lord, referred. Now, page, my lord.
Where is NHI DCL? NHI DCL. Oh, I have not seen you.
Paragraph 27, first judgment, paragraph 27, the enter paragraph, my lord,
Which one you are referring to?
Prakash asphalting, my lord.
Prakash.
This is 2025 SSC online SC 1959. The first one. It starts from paragraph 28, my lord, 27. And thereafter, my lord,
27.
it continues to, because other similar judgment, my lord, were referred here with some elaborations. And which is covering, my lord, my entire case. (27 to 40). 41 is the last paragraph, my lord, where court finally
Page,
paragraph 41, my lord. 41 is the last, where court dismissed it, my lord, saying that. Hmm. Paragraph 39 also important, my lord, because a beautiful issue has come up, my lord, here. Paragraph 39 also, my lord.
Paragraph 41.
1 minute.
Yes.
That's all. Done.
Yes, anything you want to show?
No, my lord, there is
Sir?
one issue, my lord, just to share, lordship, though it is not pertinent in our case, my lord, since I'm not challenging the price and all this. Paragraph 39,
You want to rely on the central court fees of con?
my lord, all the judgment referred in this particular judgment, my lord, it is there, my already. The gist of the judgment, my lord, all the judgment, my lord, coin to a particular issue, my lord, that correction can be done before publication of result, not after publication of result. And the latest judgment is very specific to that. Now, one argument was made, my lord, that the price quoted is much lower, so that in this particular judgment, my lord, so that the state exchequer would be benefited, my lord. Supreme Court said no.
That is always means.
Supreme Court said no. If the process is against the principle of law, no, that should not be considered. And the same thing is considered in this particular judgment. That's all. At this moment,
We are more into how the respondent of 4 can be included.
my
And that Messrs. Sonu Enterprise along with it,
my lord.
whether they can be included in the category of qualified candidate in a manner in which it has been done. That is the issue. Thereafter, what emerges is after opening a financial bid, if they are not to be included,
They're not.
They are not to be included.
They're not.
They are to be stopped.
Fine.
Then thereafter, everything is to be
More
redone.
More important.
Everything is to be redone.
One particular issue, my lord, I asked my client, what about this rectification window? They didn't have knowledge. They hooked into the computer monitor, they didn't find it. They said that particular page was deleted. But the reason behind making party to jam, my lord, this was that they can say that whether the page was actually deleted or not. Even, my lord, I was asked by the honorable judge, my lord, when at the motion stage, my lord, then why you have made party to jam. I categorically elaborated, my lord. But this is the reason why they couldn't pass. In that case, my lord, my bid has to be considered. My lord. Here, my lord, the acceptance of representation from non-responsive bidders amounts to permissible post-bid relaxation, my lord, and Supreme Court in Tata Cellular, my lord, very specifically asserted that mandates strict adherence to the tender conditions, my lord.
Yes, Mr. Kothari, this window is available in the GM portal.
Yes, there is otherwise, in fact, an inbuilt window also for clarification.
Inbuilt.
But
GEM provides an inbuilt window of 48 hours as well. And if the bid document, let's say, specifies a window, then that will supersede the GEM's conditions.
So ZIM contains inbuilt
Lordship,
window.
Lordship.
For bidders?
Lordship.
So the bidding process is governed by the terms and conditions of the GEM portal, but if the buyer wants to incorporate more conditions, it can do so.
Lordship.
And it can say that this condition of GEM portal would not apply in our case.
Yes,
And
Lordship.
that can be done.
Yes, yes, yes.
So otherwise it is governed by the general terms and conditions.
General terms and conditions. But subject to.
So that GTC contains inbuilt window.
No, the GTC does not specify any, there is no averment as regards that 48-hour window. But GEM portal has that 48-hour window for all bids. That is uniformly available for all bids.
48 or 96?
48-hour. So far as the GEM's inbuilt system is concerned.
How come this 96? Who had provided
So
96?
Lordship, 96 I can trace out from the bid document itself, page 105 and
Oh,
115.
that one. That is, so that is in deviation to normal 48 hours window.
Lordship.
You want to say that page 105?
Lordship, and 115 as well, I believe. 115, there's a
115 is pre-bid.
Lordship.
It looks like pre-bid.
Lordship.
I have read it.
Oh.
It is clear. 115 is clear. If any seller has any objection, grievance against these additional clauses, because these additional clauses have been incorporated over and above the ZTC,
Lordship.
right?
Lordship.
And if they have any issue, they can file a representation in the representation window, provided in the bid details within 4 days in the dashboard, right? 4 days of bid publication on GM. It is not regarding bid after bid opening. So
Right.
this 115 is not applicable in this case. Absolutely not applicable. Yes, 105, 112 or 105. In our brief, it is 112, but
112.
otherwise, Mr. Bhattacharya has said 105.
Lordship.
This time allowed for technical clarification during technical evaluation. I think whether this is incorporated at the instance of the buyer.
Lordship.
Otherwise, it is 48 days,
48 hours. 48 hours, Lordship.
48 hours.
Yes.
Meaning thereby 2 days.
Lordship.
But here it is 4 days.
Lordship.
So it is other than normal,
Lordship.
right?
Yes.
And in your affidavit,
Lordship.
that whether notarized undertaking is part or not, but which paragraph you have?
Lordship, paragraph 6. Page 119. So far as the document is concerned, that is at 429 to 431. Page 429 to 431.
420.
9.
It contains a bid document of respondent of Ford
Lordship.
only.
No, Lordship, since the order stipulated Sonu Enterprises as well, so
Okay.
bid documents of Sonu
Whether it
Enterprises.
whether it had the document,
The undertaking, Lordship,
the Sonu Enterprise,
yes,
authorized certificate,
yes,
which page?
Lordship, I'll just have to trace it upwards. I'll just take 1 minute, Lordship, I'll trace it up. Oh, 524, 524, I believe, is the from the bid document itself, 567. Okay?
524.
Yes. And 567, Lordship, 567.
567.
567.
What is the last date of submission of bid?
Lordship, 12th September.
12 September.
22.
12 September? Mr. Aforesaid?
Well,
Yes, anything you want to highlight?
Lordship, apart from this, no. If required, I have other datas also, so far as when the certificate was uploaded, what was the timestamp. So if required, I will clarify.
Which certificate?
The subsequent certificate.
That is on 24.
Yes, 24th, 8:37 AM.
Yes, Mr. Borua. There is one submission. Come to page 18 of the writ petition.
Lead petition, yes. Lead petition. Lead petition.
Yes.
Well,
Clause 4.
none of the staff, that is, I'm reading Miller, none is NHDC, their relatives or any of the contractor, vendor, agencies assigned work contracting will be considered for bidding in hiring vehicles. A certificate to seeker should be furnished by the bidder along with the here Miller.
Come to page 23.
23 Miller. That is remand for Miller.
Not, no, page 21. Page 21.
Miller.
22.2, clause 2.2. G.
G. Undertaking on stamp paper for providing vehicles in case of award work.
That is, I think, page 37.
Format is given, Miller. No.
Mr. Bhattacharya, your submission is this clause 2.2.G
My lord.
is relatable to page 37?
Yes, Lordship.
Okay.
Yes, Lordship.
Okay. That's done. So, this is page 37. So, reading all the three things together, whether apart from the undertaking, wherein paragraph 4, it says about say no relation, any additional certificate is required.
Yes, yes.
Clause 4.
Yes, sir. Actually, I'm little handy. Left side, my letters is there after stroke. 18, page 18. Here, Miller, again I'm reading. This
I
four.
have read a certificate in this regard should be furnished by the bidder along with a technical bid.
Yes, Miller.
Now, is it a certificate different from this undertaking?
Of course. Contents is different. Showing different by this. But basic things, your lordship, we
No,
have to see.
basic things, you don't go by basic things. That's your stand is, I have read your affidavit. There is nothing like, and it has not dealt with this issue, which he has raised. Whether that notarized certificates would suffice or another certificate is required. I want to hear from you. Yes or no?
That is a crucial point for me also. Anyhow, being a counsel, I'll try to, because that is the region. Again, I have to use that is which lordship doesn't allow this about thinking. Because here,
Your yes or no will,
it will be, my view, it will be yes, my view.
you will not do.
That
What
way,
the
now,
tendering authority thinks.
then I have.
What is in the mind of the tendering authority that, okay, notarized certificate would be sufficient.
I have understood.
Notarized certificate is alone is not sufficient. There should be a certificate.
Certificate also. This is a very crucial point me now because
Not
being
crucial point if you have
because no
not
because why
crucial
because
point if you have
crucial is
read
there.
everything.
Why because my lord this one because this though it is a certificate it is written here certificate. That is when it is giving this format. My lord.
Yes, Mr.
This certificate because this certificate word is certificate, but we are giving a different format.
Yes, Mr. Burua, I have heard you.
To start with this answer, my lord, your lordship will come to page 65.
Can you resume after 5 minutes?
Yes, yes. To the queries raised by your lordship to
Yes.
Mr. Borua, page
Page
65, my lord.
65.
Yeah. No, sorry, my lord, it is. Page 59.
59.
Part of the affidavit, it says, my lord, it is pertinent to mention herein that Inadvertently, Messrs. Kamaikya Travel was disqualified for want of non-submissions of certificate. That none of the staff, NHI, DCL, their relatives, etc., participating in the bid. But on reckoning of the submitted bid by committee on so and so, it was found that the same had been uploaded. So this is their stand. They say it is inadvertent. My lord, I find, my lord, from the submissions made by the petitioner, that they have not come with clean hands before the court. But that clause 4, they know about it, that 4 days window, they have not challenged that. Then there is a letter also saying that if somebody wants to give that the representation, you may submit that representation. I have given that. That also they have not challenged. So without my lord, bringing all the facts before your lordship, they have come with the petition that after they state their contention is that the technical bid was open. This is the result. Then thereafter, financial, he was made. The rest of the matters which was in between, it is known to them because it is in the portal. So therefore, they should have challenged it. Even after filing of the affidavit, when they come to know about it, they should have challenged it. They have not challenged this. So on that ground itself, the writ petition, my lord, is liable to be, my lord, dismissed with cost, my lord, because they have unnecessarily, my lord, taken the parties to the court without bringing the real facts before the court. And my lord, another factor is, my lord, that 2.1. Lordship will kindly see page 21. What are the documents necessary? 2.1. All the documents have been met by the petitioner, by the respondent number 4.
Confusion has been created, Mr. Das.
Yes,
because of your affidavit.
my affidavit. Respondent number 4.
Yes.
Kamaikya.
See your first annexer.
Yes, page 79. It was
You
uploaded.
prepared a certificate subsequently,
Yes,
right?
yes, yes.
Then in next annexer, you certified.
Because this is
You
what they
certified and your statement, I hereby represent certified, as if on 24/10.
yes,
Right.
that is there. Because of the letter.
And your affidavit is silent about the notarized undertaking.
The notarized undertaking
Right.
is besides
And
the
that
notarized
has troubled the court.
My lord.
That has troubled the court. You were silent. If that para,
We should have added that. I
para
understand.
4 of the prescribed form of undertaking at page 37
Yes, ma'am.
is itself the certificate
Itself
as indicated in page 18. That could
Yes.
not have created the confusion in the
Confusion.
mind of the
I
court.
understand. I'm sorry.
And that is the specific query I put to Mr. Borua,
Borua.
which he could not satisfactorily
Answer. So therefore,
convey to the court.
so
That is
therefore,
what.
if your lordship looks into the whole aspect of the matter, the respondent number 4 has fulfilled all the conditions of the bid document. And the
So that is why the neutral party has to be brought in. They have been asked to file the affidavit. Otherwise, because of the variant stand, divergent stand in the affidavits of the respondent number 1 and the respondent number 4, the respondent number 3 has to be called and to file the affidavit to bring in the technical bid of the respondent number 4. Otherwise, that occasion would not have arisen.
I understand.
Because of the stand in the affidavit of the respondent number 4.
He has stated only the subsequent. Well, it is.
Had your affidavit been in alignment with the respondent number 1,
I understand that.
that could not have created the confusion. As if your affidavit, if you read the affidavit, you are silent on notarized undertaking.
They have not brought, I mean, I should have
No,
brought it.
notarized,
Yes, I should
first
have.
he
brought it.
insisted, the petitioner insisted that notarized submission of the notarized undertaking is an essential document. Being an essential document, it was not submitted, and from your affidavit, it appears that you did not submit.
No, we submitted. Man.
And they said it was submitted. They say it was submitted.
So,
Right.
Lordship had to
And
bring it.
and in the bid, your notarized undertaking is found in a different spiral bending.
Different spiral. Man. We have
So that
submitted
created more doubt.
2925.
That created some doubt whether it was part of the original bid or not.
And therefore, you have your Lordship.
Yes.
Voting. Jen. Understand, man. So therefore, your Lordship is going to look into whether that.
We have to see the
70
decision-making process.
Decision-making process.
Only
There is
the
nothing wrong in
decision-making
the
process,
decision.
whether with the terms and conditions of the GM portal and the bid document, whether this is a permissible thing to do.
They have not challenged that.
Right.
Well,
Whatever is there, and ultimately whether it is permissible, then whether they have the decision-making process was fraught with any infirmities. If it is not, then the decision is not to be.
interpret.
That is what we are looking into it. And their case is that how this respondent 4 and Messrs. Sonu Enterprise can be transferred from disqualified category to qualified category. But their petition is silent about that evaluation done on of the technical bids or results declared, so-called results declared on 30/10/2025.
Results declared been received.
So-called,
process.
they are silent.
It was like a
So
preview.
court has to look into it, that's all.
Like the Tata Cellular paragraph 77. Lordship knows about it.
Okay.
They have, in the Tata Cellular, the intervention of court is restricted to certain points. It's very clearly written there. But apart from that, when the respondent number 1 and 2, by that rectification window, that one particular document was missing. Evidently, they come up and see the document again, which document is missing. And naturally, this clause 4 come up to the notice, saying that the certificate has to be issued. Accordingly, they have issued it. I'm not on that point, just for an. Now, kindly see one paragraph of my rejoinder, madam. Page, madam. Just a minute. আমাদের রিজনটা কোথায় গেল? Just a minute, madam. Just a minute. I'll reply. This is all the China. Yes, madam. Page 88.
80.
88. Double 8,
88. 88.
This is my research, madam, on the GEM portal function.
88.
88. 13. It starts with 13. The deponent petitioner.
Just a minute, because my pages are repaginated. So which paragraph?
Paragraph 13, madam.
13.
13. That the deponent petitioner states that the government e-marketplace portal is a public procurement platform designed as a digital marketplace where government departments, ministries, and public sector undertakings procure common goods and services directly from the registered sellers. It provides an automated, paperless, and cashless ecosystem for streamlined purchasing, featuring e-bidding and other mechanisms to ensure transparency and efficiency. While the portal offers a variety of features and services to facilitate procurement, it is incumbent upon the procuring entity to clearly specify the tender document specify in the tender document the features and procedural safeguards that the bidders may rely upon. That is the purpose, my lord, I've written it. Because GEM has got multiple features. Now, which features to be suited to my organization, my lord, I have to decide. And that part has to have the reflection in the tender document. The tender document is absolutely silent on the particular issue that there is a rectification window, and after publication of result, which is against the principle of law, as per the judicial pronouncement, number of, my lord, they rectified it. And accordingly, response number 4 was awarded the contract. That is wrong, my lord. To that place, my lord, my bid has to be considered, my lord, may be considered. That's your lordship.
Okay. Uh, Court will try, actually, a series of interviews lined up. Yesterday also it went past 7, 8 o'clock. So I'll try. If time permits, I'll do it, or otherwise I'll reserve it.
My lord.
Right? Better not to reserve it.
Not to read them.
Better not to reserve it, but let me see in the evening. If the interview is over by say 5:30, then I'll try to complete it. And but if I think that by tomorrow or day after tomorrow morning,
Leaving it too long.
I can upload, then I'll not reserve.
Well,
Right? Otherwise, it goes
I understand.
many days behind if I reserve it. So it will be SP Aforesaid, petitioner, C. Borua, standing counsel NHIDCL, for respondent number 1 and 2, Mr. D.K. Kothari. Y. Kothari. In another case, same issue has come up yesterday. I have asked the petitioner to serve a copy upon you. Right. But don't come up with this kind of availability. And Mr. B.D. Das, senior counsel, is state by MS Ardeka. That's one number 4. Huh? Okay, Mr. Aforesaid and all, we'll try to do it by tomorrow or maximum by
Day after.
day after, during the course of the day, Thursday.
Your Lordship, I'm extremely sorry for my behavior. It was absolutely
So that is
unintentional.
the practice in the Supreme Court, but we don't
Deeply-
do it because that we get distracted.
I will keep
If
it in
two
my mind.
counsels standing, who is going to speak?
I will keep it in my mind. Deeply obliged, Your Lordship.
Supplementary list for orders. Item number 7.
May it please, your Lordship. Lordship, in this case, admitted amount order of 2022.
Just a minute.
Lordship, we have filed our affidavit.
You have filed.
Lordship.
It is on record.
But my lord, the
It
case
is on record or not?
not record, but
Just a minute, sir.
Write it. Write it, please.
Yes, Mr. Kandala.
my lord, on 8/12/2025, the Honorable Court directed to produce the head of account. My lord also 27 to also directed to produce the head of the account. In affidavit, nothing is there.
What about the, I don't have the, let me see, office note.
In affidavit, my lord, they are saying that they have written some letter to others, some, only this, my lord.
Who has filed the affidavit?
Affidavit, my lord, joint commissioner.
What is the affidavit?
Order is specific, my lord. Affidavit is something else.
Miss Bora,
That's,
direction are twofold.
that's,
To verify the claim of the petition,
that's it.
and second, to make admissible payment.
That's it.
It was in September 2022.
That's it.
And this contempt petition was filed in somewhere in 2023. Period was 23 months. So it has become more than 3 years.
That's it.
What is the verification of the claim?
That's it. As per, we have filed.
We have seen blah, blah, blah in the affidavit.
That's it.
Where is that verification of claim? 3 months, which you have taken more than 3 years. Where is that state that we have verified?
Because let's say we have already sent letter
Sending letter is
and
not
submit
there.
the,
Who are the parties here in the contempt petition?
My lord, the commissioner, the district commissioner and BDO.
let's say in MG Andrega, DPC is the main person, means district commissioner.
Hmm?
DPC, district commissioner is the main. MG Andrega.
Mr. Khanukar, let it be on record, then we'll pass the detail.
My lord.
M.R. Khanukar for the petition. Who is for respondent number 1?
I'm for respondent one.
Mr. A. Bhattacharya. You are in what capacity?
I was commissioner, my lord. I was transferred on P823. In my place, respondent number 5 is transferred.
How many amended cost title?
My lord, amended cost.
You are for Bikram Koiri.
I'm from Gauhati.
Who is for Dibakar Nath?
For the government.
Bobita Kolita. You are
I'm from respondent 3.
Bobita Kolita.
No. I'm one of the person.
Huh?
Now, he's earlier Bobita Kolita, the video. Now I have him.
No, I am going one by one. Let us. How many amended cost title?
Lot 2.
In Guru format. One is Bikram Koiri, second is Dibakar Nath. Three is Bobita Kolita, 4 is Joy Sibani, 5 is Kirti Jalli.
4, 5. That's
Ah.
why I'm for 4 and
So you represent 4 and 5.
4 and 5. 4 has already transferred. Now 5.
Hmm?
4 has already transferred. 4 also transferred.
4 also transferred.
That's it.
Now it is 5.
5. That's it.
It is 5 who has filed the affidavit.
That's
Who also filed that?
Huh?
Respondent number 2. And now one of has been released from the district commissioner from the.
He also filed.
Who affidavit filed in the.
Dibakar Nath, my lord, filed 2 affidavit.
What is FTO?
My lord. F. F.
FTO is a fund transfer order.
Dibakar Nath has filed an affidavit.
Two affidavit.
Two affidavit.
One man of the date file and one I lordship. That's it.
Just a minute.
One is file of 24th February. 24th or 27th February 2024.
That I have seen.
October 2020.
October
2020.
2000.
24.
Now, Mr. Khondokar,
My lord.
come to the second affidavit.
That is space, my lord. Running space.
Second affidavit of respondent of Dibakar Nath.
My lord. 2910.
Or whatever.
My lord.
Paragraph 5.
My lord.
Subparagraph.
Be it stated, my lord,
Ah.
that the deponent had already submitted a verification report along with copy of schedule of requirement of labor and the materials under MGND is a permissibility documents before the Commissioner PNRD Assam so and so as asked by
Where is the verification report?
20.
It's not sure that be first everything. 832. Within the communication to the
A communication, but he says verification report along with as asked by so and so. 2002-2023. Where is that?
It's 31 first video, and it's a
Annexer A.
okay, page 31.
This is the verification report. Communication report. Where is the verification report?
Verification report for NS.
Regarding
Why?
submission,
Why it is not there?
Commissioner office.
That is what I have understood, but why you have not enclosed it in your affidavit? If verification, that is one part of the direction, verify the claim. And second part is admissible amount. We don't know about uploading and all this. But it is then whatever you recover from earning officials. But where is the verification report, sir?
Report not.
What report is not available, cannot be said now. After you said in page 44 that you have submitted already a verification report along with the copy of schedule of requirement as a permissibly document before the commissioner. So other than Divakarnath, nobody has filed affidavit. Other than Divakarnath, nobody has filed affidavit. No.
only on 20, my lord,
Huh?
on 20 of this month, my lord, I have
filed.
given, co-joint commissioner has filed.
Right. That is not still on record. Other than this, other respondents are not.
That's not. That's only BDO, my lord.
No, BDO has been asked to look at the earning officials so as to recover the money. Right.
Only 3 respondents, my lord.
BDO has been asked to find out who had issued the supply orders, who had done this closed instead of ongoing without uploading the material bills. And there is a direction to recover the amount from them. Ultimately, you have to be paid.
My lord.
That is MJ and Rega, if it is not permissible, this bamboo fencing or whatever, but they have said that we'll recover the money.
It is their duty, my lord.
Let it be on record so that we can read beforehand. নাম যেটা লিখব এমআর খন্দকার petitioner কলো নেকি নামকেইটা? নামকেইটা কৈছো আগত? Huh? Okay. Who is for response number 1? Mr. A. Borosaiji, learning counsel for the response number 1. Mr. J. Hendrik, learning counsel for the response number 2. Mr. G. Bokoliel, learning counsel for the response number 3. Response number 3.
Yes, in the second way.
It you.
7.
You are not for Bobita Kolita.
No.
Okay. And Miss N. Bora. You are for Joy Sibani and Kirti Jalil.
Lordship.
And Bora. N for Nogao. Right?
Lordship.
Learning counsel for the response of 4 and 5 are present. First of Miss Bora has submitted that an affidavit pursuant to the direction, pursuant to the order dated 27/2/2026. The response number 5 has filed an affidavit. First, however, the said affidavit is not on record. Where Mr. Khandoka has submitted that the direction in the order dated 21/9/2022, passed in WPC number 6864/2021, were twofold. Within bracket 1, Roman 1, to verify the claim of the petitioner. For the amount of rupees 7,50,807, and to make payment of the admissible amount. First of the direction one was to complete the entire formalities within a period of 3 months from the certified copy, from the date of receipt of a certified copy. Post of para. He has further pointed out that the response number 2 in the affidavit filed on 30/10/2024 has categorically stated that a verification report along with copy of schedule of requirement of labor and materials under the MG&REGA scheme as permissibility documents was submitted before the Commissioner Panchayat and Rural Development Department, Assam on 20/02/2023, as asked by the Commissioner, Panchayat and Rural Development Department, Assam on 6/2/2023. Full stop. Mr. Khandoka has submitted that in the affidavit filed the respondent number 5 has maintained complete silence on the verification report forwarded by the respondent number 2, that is the District Commissioner Dhubri, on 20/02/2023. Full stop. Maintaining complete silence on the verification report is suggestive of an act of contempt on the part of the respondent number 5. Full stop. Maintain complete and I am maintaining complete silence so and so and not non-dispersal of the amount found admissible are suggestive of some contempt on the part of the respondent number 5. Full stop. Mr. Henrik Lanet, counsel for the respondent number 2. As the verification report is not part of the case record, Mr. Henrik Lanet, counsel for the respondent number 2, shall bring the verification report on record by way of an affidavit. Full stop. Para, the Lanet counsel for the respondent number 5 shall file a further affidavit on the action taken on the verification report submitted by the respondent number 2 as far back as on 20/02/2023 by the negative listing. So stop. The affidavit in opposition of the affidavit of the respondent number 5 stated to have been filed today.
Lordship, on 20, they have filed 23.
Stated to have been filed, be brought on record. Lease the case on review details.
2704.
Because we cannot execute, we can only punish. I can't read it. Same. Very big. No. Dates are after going through
We have
affidavits, 2 affidavits file. Mr.
That's it.
Don't say that same.
We have,
Where is the second affidavit of the?
we have also filed affidavit for the.
Okay, madam, wait. Dibak or not? Okay, first Likhok M.R. Khandogan, petitioner. Here it is not there. A Bhattacharya?
No.
Huh?
I'm not there.
Who are the parties here?
He was there, my lord, but perhaps.
No, who are the parties? Please tell me, Mr. Khandogan, there are so many cost titles. Please tell me.
My lord, same parties. Same person.
No. Different, okay. Dibak or not? Manav Jyoti Boisho. Joy Shivani Kirti Jali. Okay, Mr. M.R. Khandokar, petitioner. Vikram Koiri.
I'm not there, because you have not filed any order from us.
Who is there? Who was there?
But I'm not okay.
Anybody appeared? Mr. Khandokar, please tell me.
My lord, not, he was not appear. In the meantime, he has transferred, my lord.
Okay. Mr. J. Henrik. Respondent number 2. Z. Bokolial. Respondent number 3, N. Bora, 4 and 5. Where is the order in the writ petition?
Read petition, my lord, order page 13.
Page 13.
Order is also same. my lord.
No, order is same, amount is same.
Amount is also same.
Same amount.
Okay, order date same. WBC number 6871. Which is? Who is the affidavit of the respondent number
2.
2 with similar statement verification report? Filed on 1/5/2023. Affidavit. Respondent number 2. Same. Date kira same. 20/02/2023. 6/2/2023. ঠিক আছে? No worry. বাকি খিনি affidavit file here also.
Lordship, we have filed
Huh?
on 23/2026. We have
এই
filed our-
5 affidavit করেছে। খন্দকার লিখে দিব। So that by giving a suggestive of example can place the case on so it's
2704.
I'm good, please.
Item 9.
May please, Your Lordship. Your Lordship, the respondent number 1 and 2 are no longer holding their posts. This case, Your Lordship. Perhaps if Lordship produces the order dated 6/2/26. Lordship, Lordship.
And what about the current status?
Lordship, that's what, Lordship. I'm praying for some time to, Lordship.
Heard Mr. N.J. Katonier, learning counsel for the petition. And Mr.
N.R. Sharma, Lordship.
P.
N.R. Sharma.
N.R. Sharma. You are standing counsel?
Lordship, Lordship.
Standing counsel BTC. Was asked to obtain instruction about the current status with regard to the process relating to payment of outstanding dues to the petitioner. Mr. S. Bora. Lennox. Counsel. An application has been submitted by Mr. S. Bora, learned counsel, who used to represent the respondent number 1 and 2 earlier, stating that the occurrence number file on behalf of the respondent number 1 and 2 by Mr. D. Shoikel and senior advocate, Mr. S. Bora, Mr. P. Nayak, and Mr. R. K. Musari, learned counsels, be involved. And be recalled by deleting their names from the call list, post them, and the registry to delete the names of the councils aforementioned counsel from the cause list, from the respondent side in the cause list. Full stop. Para. As Mr. Sharma has submitted, Learned Standing Council, Mr. Sharma, Learned Standing Council has submitted that the incumbents, the respondent number 1 and the respondent 2 impleaded in this contempt petition are no longer holding the post as shown in the complaint. Yes.
Incumbent
Mr. Khatun, Mr. Khatun, Learned Counsel for the petitioner has sought 2 weeks' time to file appropriate pleadings for impleadment of the present incumbents holding the respective offices. A prayer is allowed. This is the case on so and so. Mr. Sharma, Learned Standing Counsel, shall obtain the instructions as regards the process of payment to the petitioner and to place the same before the court on the next date of listing. The name of Mr. M.K. Sharma, Learned Standing Counsel, PTC.
Lordship, if I may pray, Lordship, the name of Mr. A.K. Bhuiya be shown, Lordship. He's the senior standing counsel. Will his name be shown on call list?
You be there. I am not making you responsible.
Lordship.
I am not making you responsible as
Lordship.
a standing counsel.
Lordship.
Once you enter into defense on behalf of them, we'll make you responsible. Now you assist the court as a standing counsel.
Absolutely.
Right? Place the case on so.
Court may.
But you have to file impleading petition.
In the meantime, I'll.
Obliged, Lordship.
Obliged.
This non-compliance of the order and judgment dated 14/2025. And the relevant portion is page 12. They have filed affidavit in opposition by respondent number 1 and 2. But kindly peruse para 20, para 6.
Respondent number
Para
1.
1 and 2 both are filed.
Rahul Kumar Gupta.
Page 20, well, running page 20, para 8. The statement made in paragraph 4 of the contempt petition, the answering department makes to state that the answering respondent has taken all possible steps to make the payment of the petitioner dues after receiving the copy of the judgment of the Honorable High Court. But it's pertinent to mention here that unless the funds are received from the government of Assam, from the General Admission Department, the payment of dues cannot be made. Once the fund is made available by the so-and-so, the payment shall be made. And the same condition was clearly mentioned in point number so-and-so order that the higher charges shall be paid when fund will be received from the government. And therefore, the case is liable to be dismissed at this stage. And direction was to clear the dues within a period of 3 months.
So this is the stand.
This is the stand in both the affidavit.
Both the affidavit.
Both the affidavit.
It is a contempt petition. It is a contempt petition. So Mr. Todd, this is the stand.
My lord,
Okay,
my lord will come to the direction. I just want to read my lord one.
So 1 and 2 has admitted, but because of the fund.
Yes.
My lord, whether there is a willful and deliberate, my lord, disobedience. My lord will, this is a contempt case, my lord. So whether did respondent number 1, I am appearing for 1, my lord,
Ah,
willfully, my lord,
ah.
disobeyed the order. If there is any negligence, my lord will come to page 12 of the contempt petition, para 9. I'm just reading it, my lord, for my satisfaction, my lord.
Para?
Para 9, my lord, of the order. That is page 12. It starts. Considering the submission, my lord is there, my lord.
Page.
Page 12, my lord.
12
My lord, of the contempt petition,
of contempt petition.
my lord. That is the direction of the honorable court, my lord.
Para?
12, para 9, my lord. My lord is there, my lord. Considering the submission made by the learned counsel for the parties, this court is of the view that this matter need not be kept pending for want of instructions. Accordingly, the matter can be disposed of by directing the authorities concerned, more particularly respondent number 2 and 3, to examine the claims raised by the petitioner. So, my lord, direction is in two folds. First is to examine. Examine the claims raised by the petitioner. That is one fold. And if found so to be correct, then the same should be released following the guidelines of Tamsher Ali versus State of Assam. That is the, my lord, second fold, my lord, following Tamsher Ali. The entire exercise of verification and payment of the admitted amount should be completed by the respondent as expeditiously as possible, preferably by the outer limit of 3 months, my lord. So, my lord, now I find there is threefold. One is examine, my lord. Then Tamsher Ali, you have to follow Tamsher Ali, my lord. And then, my lord, if he is, my lord, eligible, the claim is correct, then we have to pay. That was the direction, my lord. My lord, following this, what respondent number here, respondent number 1 did, my lord, the DC. My lord will come to first page 25.
Verified.
We have verified, my lord.
Correct.
Correct.
Only thing is that GAD.
My lord.
That is the issue?
That is the issue, my lord. GAD is not a party. Was not a party in the writ petition also.
What Mr. Islam will submit or not, I don't know. Right. You be there in the proceeding. But have you informed the GAD?
Yes, my lord. We have informed.
Good.
We have informed. We have written letter.
Statement is there.
My lord.
Categorical statement is
yes,
there.
My lord. Even annexures also we have.
Very good.
We have informed the
you
GAD.
You have done good thing.
We have informed the GAD.
Good.
My lord, let
good
me.
Thing.
My lord,
no. It's okay. It is the responsibility of GAD and not responsibility of the 1 and 2 to make the payment because that is out of their control.
Yes.
That is your case.
Yes, my lord.
Is it not?
This is beyond our control, my lord. We have to get the fund, my lord.
Right. So fund has to be provided by GAD.
GAD.
Okay. So, Mr. Islam, you go through, write down.
Yes.
Write down. Israr, ISRAR. Ahmed, AHMAD. Khan versus Amarnath Prasad. 2026. INSC 209. Right?
Yes.
You have read down. So, there is a discussion, right,
Yes.
on the issue. Liability of third or non-parties for contempt. How third parties or non-parties to the original proceedings. Writ petition, GAD is not a party.
Yes.
Can also be proceeded against for contempt. Detailed procedure is laid down.
Yes.
file a, after reading this,
Yes,
make the pleading
yes, my lord.
and file an
I have
appropriate application for impleadment.
Yes,
Will proceed against GAD. Have you
yes,
understood?
understood, my lord. But herein one thing, my lord, I have
No,
not,
that is all.
yes,
Once they have admitted,
yes,
liability is admitted.
yes,
Now fund, they said,
yes,
it is the liability of the GAD.
So I
Now
have to-
GAD has been made aware.
yes,
So Supreme Court has said, discussing precedent,
yes,
even if in the original proceeding, the party is not, but if it has been made aware
yes,
of the direction
yes,
by the contemners,
contempt.
and even if that party is non-party in the original proceeding, but
Then
they are still liable for contempt.
Yes,
Right?
yes,
So,
yes, I'll file.
end of the issue.
End of the issue, but there is no quarrel in this.
Heard, Mr.
My lord will
Islam.
just peruse page 26 once for my satisfaction, my lord.
What satisfaction?
Page 26.
I am keeping you in the loop. If the GAD comes up, we say no fund is available.
Yes.
Then things will be different.
Obviously.
So let
No, my
you
lord,
be in the loop.
I will be there. I'm just page 26, my lord, of my affidavit.
26.
26, my
Oh,
lord.
he written. Very good.
That is what I want to.
That is what I said. Your statement is enough.
Yes. My lord.
You have informed the GAD. So, if have you understood?
Yes, I have.
Go through the judgment
I have understood.
and get it done appropriately.
Yes.
I heard Mr. R. Islam learned counsel for the petition. And Mr. Ardhor for
1, my lord, respondent number 1.
learned counsel for the respondent number 1. And Mr. A. Soria learned counsel for the respondent number 2. Post of Mr. Islam learned counsel for the petition has submitted that from the statements made in the affidavits in opposition of the respondent number 1 and the respondent number 2 respectively, it is clearly discernible that the respondent number 1 and the respondent number 2 have both admitted the liability to the extent of the claim made by the petitioner. Post of. However, the respondent number 1 and the respondent number 2 have taken a stand individually, but commonly, that the liability to disburse the fund lies with the General Administration Department. Full stop. It is a submission of Mr. Dhor and Mr. Sohoria that as the General Administration Department was not a party respondent in the original writ petition, WPC number 5083/2024, the present contempt petition cannot be proceeded further. Post of in response, Mr. Islam, learned counsel for the petition has submitted that even a non-party can be proceeded in a contempt petition if non-compliance of if the liability to comply with the order or direction in the original proceeding is made aware. If such non-party in the original proceeding is made aware of the order or direction passed in the original proceeding, full stop. In such view of the matter, Mr. Islam has sought for 2 weeks' time to file appropriate pleading, seeking placing justification for implement of the General Administration Department by placing proper justification. Full stop. The prayer made by Mr. Islam is allowed. Lays the case on.
After being
On. Okay. By that time, I should be there.
Yes, my lord. I'll file within 2 weeks, 2 days. my lord.
Lays the case on 24,
Yes, much.
24th April.
2026.
My lord.
Much.
Obliged, my lord.
Go to the region.
Yes, my lord, I have seen, my lord.
11 and 12.
Yes,
Yeah, please, Lord.
Yes, Mr. Das.
Lordship.
Typographical error.
Lordship.
Heard Miss P. Odhikari. Learned counsel for the applicant. And Mr.
K.K.
P.P.
Das.
Das.
KK Das.
K.K. Das. Learned additional public prosecutor for the opposite party number 1. Miss
M. Deka.
and Miss M. Deka, learned counsel for the opposite party number 2. Post up. Do you have any objection?
No, Lordship.
Post up. The instant application, interlocutory application is preferred by the applicant seeking correction at certain places, correction at certain places, seeking corrections at certain places in the order in an order dated 7/1/2026, passed by this court in criminal petition number 1582/2025. Post of para. The applicant as the petitioner has preferred the accompanying criminal petition, criminal petition number 1582/2025. Assailing an order dated NA 2023, passed in the complaint case, CR case number 136/2023, passed by the Court of Learned Judicial Magistrate First Class, Jorhat, and also seeking quashing of the proceedings of PRC number 134/2025, registered under section 384, Indian Penal Code, and presently pending in the Court of Learned Judicial Magistrate First Class, Jorhat. Full stop. Para. When the criminal petition was moved on 7/1/2026, this court while issuing notice, making the notice returnable on 16/2/2025, passed an interim order to suspend further proceedings of PRC number 134/2025 till the returnable date. Full stop. Para. In the interlocutory application, it is averred that at two places in paragraph number 3 and paragraph number 8 of the order dated 7/1/2026, it is typed as quote unquote, the Court of Judicial Magistrate, First Class, Kamrup, unquote, instead of quote, the Court of Judicial Magistrate, First Class, Jorhat, unquote. Full stop. In the order, comma, at paragraph 4 of the order, comma, instead of quote, section 528 of CR full stop, T full stop, C unquote. Instead of quote, section 528.
Number 8, Lordship, not
Huh? You said para number 4?
8, Lordship.
8.
But here it is stated para 4.
Para 4 only. 3 and 8 already corrected.
Para 4.
In para 4 of the order, comma, it should have been quote, section 528, comma, BNSS, unquote. Whereas it has been typed as quote, section 528, comma, CRPC, unquote. Full stop. Para, the learned counsel for the opposite parties are also in agreement that, also in agreement with the petitioner, that also in agreement with the applicant, that the errors which had occurred are typographical errors. First of all, as the errors which had occurred inadvertently are typographical errors, as the errors, comma, indicated above. Mention it, comma, are errors which are clearly typographical errors, comma, the instant interlocutory application stands allowed, full stop. It is made clear that at paragraph number 2 and paragraph number 4 of the order dated so and so, it should be read as quote, the judicial magistrate, read as quote, the court of judicial magistrate first class, comma, Jorhat, unquote, instead of the court of judicial magistrate first class, Kamrup, and in paragraph 4 of the order, it should be read as quote, section 528, comma, BNSS, unquote, instead of quote, section 528, comma, CRPC, unquote, full stop. It is also ordered that this order is to be treated for all intents and purposes. This order is to be treated as part and parcel of the order dated 7/1. Other hearing, have been long.
Here,
Anybody hearing is available? I'm not taking up this case, hearing cases.
so in this case, what happened, the name of the petitioner's counsel has been reflected.
Is it so?
Yes, it was the.
Which
reflected-
one? Which one?
Item 4, Lordship.
Force, huh?
For hearing. Item number 4. Alia counsel TC.
Your name is appearing.
Yes, Lordship. TR Sharma was appearing in this newly appeared, Lordship.
So I asked you, huh?
Yes. That there are two I were disposed of. One for delay condonation, one for restoration, Lordship. Lordship has added against the management non-payment of 17D.
Years on. Okay, it is already reflected.
No,
Okay,
that-
okay.
RDA counsel.
As in the original petition.
Original petition. So reflecting the name of TR Sharma case may be directed to be listed. Lordship.
Okay. Mr.
PP
PP
Dr.
Dr. Learned Counsel for the respondent number 1 is present. Full stop. Office to list the case on so and so.
That's it.
by reflecting the name of Mr. T.R. Sharma. By adding the name of
That's it.
Mr. T.R. Sharma.
That's it. As a petitioner's counsel.
Learned counsel. With the names of the other learned counsel for the petitioner in the cause list.
That's it.
That will do?
Lordship, one date I am paying for a date.
Huh?
Date.
He'll give the date.
That's it.
30/04. 30th April.
38 April.
Yes, Mr. Mazumdar.
Lordship, item number 6. Lordship, if it's not being taken today, then
Yes, so I'll be writing for some other books.
This will be 4th of May if it's suitable to Lordship's calendar in item number 6, Lordship.
It would be way better if after BU vacation, choose a date, convenient date. Doctor, you are outstation counsel?
Yes, Lordship. Yes.
Okay.
I'm so sorry. You have the dates date from my office. Just check.
Miss Roy.
Miss Das.
I. Okay, check with the court master, right? And with him, and after Bihu, where it is, where the calendar is not that.
12th May.
Yes, 12 May. You are for the petitioner, Mr. Mazumdar?
Yes,
Okay, Mr. M. Mazumdar, MZ Mazumdar.
This will be 25th of May in that case, Lordship. 25th of May in that case, Lordship.
25th will be too long, Lordship. It is an industrial dispute and the workman is terminated from service.
Yes, it's actually.
Anyway.
Could be Monday.
Monday. Can it be 26th?
May you are saying
No, Lordship is saying May only.
May.
May.
That's what I'm saying, 25th. Then could this be 28th, Lordship? I'm sorry, I don't have the calendar. They have been, my office was
28 is okay.
Highly aware.
27 is holiday.
28th would be more up to.
Thursday.
Hearing day, 28.
28.
Hearing day,
Hearing
Mr.
day.
It's a hearing, it's a Thursday.
I have a small request, Lordship. Can it be high up in the list?
No, I don't do that. Whatever convention I am following. I stick to that. Even in a course of day, I don't upgrade.
We'll go for our astrologer and get good like this that day.
And Mr.
Anurag Lakhotia, Lordship.
A. Lakhotia, Learned Counsel, which means IDAS Learned Counsel for the sole respondent.
Yes.
For the respondent. First up. I have sought for and agreed to by the Learned Counsel for the parties. This is the case on 28/5/2026.
Highly aware, Lordship.
What is the hurry for you? You are always here. It is his.
No,
Okay, we'll take
urgency is from a client's side.
We'll take up next.
Highly
Yes,
aware.
authorized.
Highly aware.
Sankar Ghatua.
Item 5.
Yes. What is the issue here?
It's a petitioner challenging his disqualification on technical bid in an IMFL off license, Your Lordship. That's the challenge he has made in the writ petition.
Any interim order operating?
No.
And I'm license is granted.
Issued. IMFL off license in excise
Off
department.
license has been granted.
License already issued.
Mr. Soma, you are here in a busy election season.
No, it is an election. I'll go. I am in charge of Gauhati city.
Okay.
Five constituencies.
Mr. Sarma, today I'm not taking up. Because some other emergent issue.
Yes.
Right. Can you
If they
find out a free date for
but if
Mr.
and
Dole?
before-
Find out a free date as per the convenience of Mr. Sharma.
6th April, my lord.
6th April, no, not possible. Is it so urgent? Or 20th April immediately after vacation?
They'll come after vacation also.
Okay.
Right. We'll take up, if possible required, we'll go for next day also.
Yes. 20th April is, I think,
Right.
Tuesday, no?
Mr. Abhishek, due to early rising of the court
Tuesday.
at 3:15 p.m. The case. Huh?
Tuesday.
Due to early rising of the court at 3:15 p.m., the case could not be taken up today. First up, Mr. R.P. Sharma as senior counsel. Listed by Mr. D. Dole, learned counsel for the petition, and Mr. R. Gogol, learned standing counsel, excise department. You were there? For whom? Okay, miss. Tell your name. Three Sarkar Land Constable Response number 8 are present. List the case on 21st of April. 21st of April. Hearing it.
Obliged, Lordship.